Why India's judiciary is weaponizing forensic science against rural land disputes, and why it's break. The spectacle masks a systemic collapse. On the surface, Bihar police ordering DNA tests on a buffalo sounds absurd enough to go viral, and it will. The story has all the hallmarks of viral Indian media: rural whimsy, technological overreach, a court unable to solve something with common sense. But zoom out, and you're looking at a far more consequential problem. India's judiciary is systematically outsourcing adjudication to forensic science because it has abandoned the harder work of actually interpreting property law in the rural context. The Buffalo case in Bihar is not an outlier. It's a symptom of a judiciary that has become risk-averse on ambiguous rural disputes, rather than wade into murky questions of customary grazing rights, shared herd management, or succession disputes under Hindu Succession Act amendments. Judges are latching onto objective scientific answers as a shortcut to finality. The problem: forensic technology cannot and should not resolve questions that are fundamentally legal, not biological. The rural property rights crisis hiding behind the DNA test. India's rural property system operates on three overlapping frameworks. 1. Government land records, often decades out of date, with 15 to 40% inaccuracies in states like Bihar. 2. Customary practices, transactional patterns, oral agreements, seasonal grazing rotations. 3. Statutory law, succession acts, tenancy law, which have been amended multiple times, creating contradictions. A livestock ownership dispute typically hinges on one or more of these, not genetics. Consider what the Bihar case probably actually entails: competing claims to the same buffalo, likely rooted in shared herd ownership or disputed succession within a family. No clear written bill of sale or registration, since cattle commerce in rural Bihar runs largely on informal transactions. Ambiguous customary rules about who owns an animal born in shared herds or maintained jointly. Succession confusion, especially post-2005 Hindu Succession Act amendments that now grant daughters equal inheritance, creating new disputes over livestock inheritance. A DNA test will prove genetic parentage, not legal ownership. If both claimants raised the buffalo, fed it, or maintained legitimate family claims to it under competing interpretations of succession law, DNA proves nothing about who has the right to it. The judge has essentially punted the hard legal question to a lab technician. This matters because it sets a precedent. Once one court uses forensic technology to sidestep ambiguous law, others follow. Within 2 years, we'll see DNA tests for disputed goat ownership, contested land boundaries via soil composition, and possibly even claims to shared wells, groundwater composition analysis. The judiciary is outsourcing legal reasoning to technology because the underlying rural property law is fragmented, outdated, and genuinely hard to apply. The infrastructure bottleneck disguised as justice. Here's the contrarian wrinkle. Conducting a DNA test on a buffalo is not cheaper or faster than a proper legal hearing. It just feels like it to the judge. Let's trace the real costs. DNA extraction and sequencing, 5,000 to 15,000 rupees per animal. Bihar police labs are not equipped. Sample must be sent to private labs or state forensic institutes. Turnaround time, 4 to 8 weeks, versus a legal hearing that takes 2 to 3 weeks. Chain of custody documentation adds another 2 to 4 weeks of bureaucratic processing. Appeals, retesting if results are contested, resets the entire timeline. Meanwhile, a proper property law hearing would require examination of land records and herd history, witness testimony from neighbors, veterinary records, livestock census data, application of precedent under succession law, which is actually well established if underapplied in rural courts. The DNA test doesn't expedite justice, it postpones it while creating a false sense of objectivity. The judge feels absolved because the answer came from a machine, not from an interpretation of ambiguous statutes. This has massive